Welcome.
Okay. Good afternoon, judges. My name is Ramaiah, and I'll be your court officer for today. Today we have team TL3 at Petitioner and team TL1 at Defendant, and speaker 1 from team TL3 has reserved 20 minutes for this speech, and the speaker 2 has also reserved 20 minutes for this speech. And TL1, that is the respondents, the speaker 1 has reserved 20 minutes, and the speaker 2 has reserved 22 minutes, and the petitioners have reserved 5 minutes for their rebuttals, and the respondents have reserved 3 minutes for the rebuttals. With the permission of the judges, the petitioner can start their submissions. Great.
Permitted.
Okay. Petitioners, kindly start your submission.
Am I clearly audible and visible?
Yes, you are. Just when you're starting your speech, kindly give me a countdown so that I can start the time.
All right. I shall begin. Yes. Greetings to the honorable bench. Am I visible and audible?
Yeah.
Yes. May it please before the court, the counsel seeks permission to address the bench as your lordships.
Yes.
Much obliged, your lordships. May it please before the court, the current counsel is appearing on behalf of the petitioners in the case of Mr. Chetri and others versus Union of Indus and Health One. If your lordships are well acquainted with the facts, the counsel seeks permission to proceed with arguments.
Now you please state the facts.
Much obliged, your lordships.
In brief, you give it.
Indeed, your lordship.
Yes.
Your lordship, in the instant case, Mr. Tubdeen, who is a 50-year-old male, is a diabetic patient, and unfortunately, despite all the safeguards, Mr. Tubdeen was infected with COVID-19 virus. And owing to the shortage of the hospital beds, the Tubdeen was shifted to the COVID recovery facility at Badlapur. The doctors at COVID recovery facility administered Mr. Tubdeen with steroids and monitored his health condition constantly. The COVID recovery facility at Badlapur ran out of oxygen on midnight of July 7th, 2021. Tubdeen and 7 others have admitted in the COVID ward lost their lives due to lack of the oxygen supply. The hospital authorities even told the relatives of the patients to take care of the oxygen supply by themselves, as the hospitals had run out of the oxygen, and there were no chances of reviving the same. Mr. Chetri and son of Mr. Tubdeen had left no stone unturned to find an oxygen cylinder for his father, but all of his efforts went in vain, as none of the oxygen supplies at Badlapur had the oxygen to refill the oxygen cylinders for the patients. Your Lordship, Mr. Chetri lost his father along with the others on morning of July 8, 2021. After the death of his father, the hospital authorities issued a 22-page bill of 20 lakhs for the facilities and service. In order to pay the hospital bills, he was forced to sell his auto rickshaw and spent his entire life savings, even though he could not save his father. Your Lordship, Mr. Chetri and 7 others instituted a suit against the state and Health One before the Badlapur High Court, seeking compensation of rupees 10 crores against the state and Health One on the ground of medical negligence and failure to perform the statutory duty by the state. Your Lordship, the suit for the damages also sought compensation to be paid to all the family members of all those who died due to negligence at the COVID recovery facility. Your Lordship, the state has also contended that there was no negligence on the part of the state. The act of providing medical care during a pandemic comes under the sovereign function of the state, and the state is not held liable. Your Lordship, the council seeks permission if my time starts once I begin the arguments.
Okay.
Much obliged, Your Lordship. Your Lordship, the current council will be dealing with straight away with the issue 1, that is in the instant case whether the PIL is maintainable before the honorable court. It is humbly submitted that the said writ petition should be maintainable before this honorable court, as there exists clear violation of the fundamental rights of the people of Badlapur. Article 226 of the Constitution of Indus guarantees to every citizen a constitutional remedy for violation of fundamental rights under Part 3 of the Constitution of India. Your Lordship, Article 226 does not specify the person who can approach the court under it, but as this article provides a public law remedy similar to Article 32, similar provisions of locus standi will apply to this. Your Lordship, in instant case, Mr. Chetri and others, my clients, had approached this honorable court for the violation of their fundamental rights under Part 3 of the Constitution of India. So, Your Lordship, there is an original jurisdiction under Article 226 of the Constitution of India, and it is in the interest of public at large. Your Lordship, quoting the Supreme Court judgment of in the case of SP Gupta and Union of India, it was observed that any member of public having sufficient interest can maintain an action for judicial redress for public injury arising for breach of public duty or from violation of some provisions of the Constitution or the law, and seek enforcement of such public duty and observance of such constitutional or legal provisions. Your Lordship, in instant case, Mr. Chetri and others have claimed remedy for the family members of all those who died due to negligence and the COVID recovery facility Badlapur. Your Lordship, it is further pleaded that a person acting bonfire and having the sufficient interest in the proceeding of the public interest litigation can have a locus standi and can approach the court to wipe out the violation of fundamental rights and genuine infraction of the statutory provisions. Your Lordship, in instant case, there is a clear infringement of the fundamental rights, and it is the interest of the public at large. Hence, this petition is maintainable before this honorable court. Also, the counsels for the petitioners humbly submit that before this honorable court that the remedy under Article 226 of the Constitution is a discretionary remedy. The court has vested with the power to entertain the petition where there occurs a gross negligence of justice and effective remedy is not available. Your Lordship, the counsel for the petitioner would like to cite the case of Whirlpool Corporation versus Registrar of Trademarks, in which it was held at the apex court that the jurisdiction of the High Court in entertaining the writ petition under Article 226 of the Constitution would not be affected, although there exist an alternative remedies. Lastly, Your Lordship, it is submitted that the writ petition is maintainable. There is no alternative remedy available for the petitioners, and there exists a clear infringement of the fundamental rights of people of India and the petitioner owing to the constitutional principles and the precedent set by the apex court. This petition is maintainable before this honorable court. Your Lordship,
Counsel, would you be very clear? Now you say that the petition or PIL or whatever you say is maintainable because there is a violation of the fundamental right.
Indeed, Your Lordship.
Yes, that is your argument. But your petition says that the state has violated or committed or failed to discharge its statutory duty.
Indeed, Your Lordship.
How do you reconcile that? What is your petition? Your petition is for violation of or a breach of the or a failure to perform the statutory duty by the state. Now you say there is a fundamental duty. Is there no difference?
Indeed, Your Lordship, much obliged for the question. Your Lordship, the counsel for the petitioners have also filed the suit, have also filed the petition for the medical negligence that has been performed by the state, as well as the non-performance of the statutory duty. They have also violated Article 21, that is right to life as well, Your Lordship.
Mr. Counsel, you make it very clear about your litigation is a private litigation or public interest litigation?
Public interest litigation.
All right. What is the public interest in this?
Your Lordship, as per the facts stated
and you
here,
said that you already filed a suit also. You are mixing things. Is it your case is PIL or a suit?
Your Lordship, it is PIL.
A PIL. All right. What is the public interest?
Your Lordship, as per the facts.
Can you define what is public interest?
Indeed, Your Lordship. Here in the instance.
What is public interest? What is public interest here? You are asking judicial review under Article 226 of the Constitution. The High Court has got jurisdiction. What is the public interest?
Public interest.
What is the judicial review you are asking? Here is the judicial review.
Much obliged for the question, Your Lordship.
What is the public interest in this?
So, Your Lordship, in the instant case, the public interest lies with is the family members those who have died during the COVID-19 because of the negligence of the state.
Not your case. It is not your case. That is individually, that is claiming the damages. It is your own personal case. no public interest is involved. You are
No,
not, it is not your prayer. All those who have that is suffered with this oxygen failure, that they should be provided with the damages. That is not your case.
It's a suit for compensation.
Your Lordship,
Very thing. Now, is it a suit for compensation? When there is a negligence, that is the negligence on the part of the government in not supplying sufficient, that is the oxygen cylinder, the person died. So there is a negligence on the part of the state government, either state government or a private hospital. One thing. Now, first you decide whether it is a PIL or a suit for compensation. Now you can file a suit for compensation with High Court also, provided where the chartered expert or patent act is applicable. So now it cannot be termed as a PIL, and you please establish how it is a PIL. It falls within the scope of PIL.
Your Lordship, in the instant case, the compensation is not for one person.
Yeah.
It is.
So you are asking for compensation for all those who died on account of COVID and on account of failure to supply oxygen.
Indeed, Your Lordship.
That's it.
Indeed,
So
Your Lordship.
don't call it as a PIL. It is only a suit. Suit against the government for compensation on account of a tortious liability. Is it not? On violation of fundamental right. Okay. Yes.
Indeed.
Go ahead.
Indeed, Your Lordship. Much obliged, Your Lordship. The counsel for the petitioners also request the bench to issue a writ of mandamus here. That is to something in the nature of public duty.
Now, what is the negligence? Now, negligence, you say non-supply of oxygen by the hospital, you establish it. Then you come to the report.
Your Lordship, my issue one.
It is not a PIL. It is only a suit for compensation on account of negligence. It is a tortious liability on the part of the government. Is it not? So now we please say how you are entitled for compensation and prove that what is the negligence in all this.
Indeed, Your Lordship. It will be dealt in further issues and sub-issues in detail, Your Lordship.
Okay.
Your Lordship, the counsel for the petitioners will be establishing the test to lay down the writ of mandamus in the instant case, that the Supreme Court has also laid down the test that there must be a public or the private duty. So it is submitted that the public duty was cast on the respondents to safeguard the public health and safety, which was reliant upon the standard of care. As already established, the duty was negligently performed by the respondents. And secondly, Your Lordship, there must be a specific demand and refusal. The specific demand of the petitioner is of the compensation with regard to the injury suffered by them due to the negligent act of the government by not providing necessary oxygen, and there has been specific refusal of the same by the respondents.
Ms. Counsel, please listen. It is the COVID is a new virus. It came to the country, the world. Now the government had no such occasion to take any precautionary measure or abundant caution to keep the cylinder. It is a sudden broke, and because of the non-supply of the cylinder, how can you fasten the responsibility on the government that they committed negligence? There was no such negligence. It is a sudden epidemic and a sudden thing. Government had no such intention or any material on record to show that the government had knowledge about requirement of the oxygen cylinder. Therefore, it failed to supply or make it available to the hospital. So where is the material?
Indeed, Your Lordship, in the instant case,
there should be some material to show, yeah, there was some negligence. Means whether any demand was made, whether it is a new virus has come, whether oxygen cylinders are required. If that is the case, how many cylinders? There is nothing of that. It's all vis major, all because of vis major.
Your Lordship, this is not something which the state has not foreseen. It will be there was already a foreseeability which the government had witnessed in the first wave of coronavirus. So in the instant case, this happened in the year of 2021. So the coronavirus was already began in the year of 2020. So it was very much foreseeable, and there was high chances of improving their medical infrastructure and their expenditure on health and other facilities, Your Lordship.
No, in the first wave that nobody was anticipated or foreseen that it requires, and it is going to affect to the lung, and oxygen is required. No, nobody has foreseen. Only in the second wave that it already started and the lungs required this, particularly the oxygen. So that's why there was a scarcity of oxygen. The government has taken all the steps to provide the oxygen.
That is very much evident, Your Lordship. That is very much
of its possibility.
That is very much evident, Your Lordship, that the government was clearly negligent in providing the oxygen supply. Also, in the instant case, it is said that there was loss of life because of lack of oxygen supply. If they would have provided the oxygen supply at the time, Mr. Chetri, my client, wouldn't have lost his father, Your Lordship.
So if that is the case, so here, why that you have made some efforts to go to secure the oxygen? You have also made all the efforts. You have, that is, moved heaven and earth, and you did not get the oxygen. So here, what the government could have done?
Your Lordship, here in the instant case, top researchers and virologists have advised the patients recovering from COVID-19 would need oxygen support on priority.
Right,
it has already been established that
oxygen was required for the patient. All right, oxygen was required. But now, where is the negligence on the part of the government or the authorities, hospital authorities, to say what is the number of cylinders they require? It was a sudden thing, and because if there was any notice, all right. So merely because there was paucity of cylinder and non-arrangement, how can you present the liability on the state? It is the first wave came, second wave, all right. But nobody intended, or there was no statistics on the point, or any scientist has said that you keep the cylinders ready because the patients require. There is no such thing. So under such circumstances, we can say the patient was already suffering from asthma and all. It is accelerated because of the COVID. Whether certificate, you are not produced certificate at all that he had contracted COVID. Where is the certificate to show that he was contracted with the identified as a test? 5 minutes left. Okay.
Your Lordship, in the facts itself, it is stated that he was a diabetic patient and he was infected with COVID-19 virus, where it was the responsibility of the state to take due care of their patients and their people of the state, Your Lordship. If they would have provided timely oxygen supply at that point of time, then my client's father wouldn't have suffered loss.
Whether you are admitted to private hospital or government hospital?
Government hospital, Your Lordship.
Government hospital.
Yes, Your Lordship.
So they gave a bill, is it? The government hospital has given a bill for 22 lakhs.
Yes, Your Lordship.
Now, is it a government charge? Is it a free hospital, or they are charged for all treatment? Hospital will charge. Is it a free hospital or what?
No, Your Lordship. They have charged a very high. That too, he was an auto rickshaw driver, and they've charged a 22-page bill of 20 lakhs rupees, where he was forced to sell his auto rickshaw. And this is very insensitive.
Yeah, all right, you could have asked the government in the circumstances, meet the bill, will not and exempt and all right. But compensation wise, you can say the person died, some compensation government will give it, and government has given now 50,000 rupees sanctioned by the government for all those patients who died in COVID. But you say negligence is very difficult to prove on the part of the government.
But Your Lordship, this will be dealt in detail in my further sub-issues, Your Lordship.
Yes.
Much obliged, Your Lordship. Also, Your Lordship, with your kind permission, may I move with my issue too, as I'm running out of the time?
Yes, proceed.
Much obliged, Your Lordship. My second issue is whether there has been violation of the fundamental rights of people of Indus. It is humbly submitted before the Honorable Court that the government low priority on the medical sector and failed to build the necessary infrastructure has violated the fundamental rights of people of Indus. Your Lordship, Article 21 of the Constitution casts an obligation to the state to preserve life. Social laws do contemplate death by negligence to be tantamount to be legal punishment, whether at government hospital or otherwise, has the professional obligation to extend services with due expertise for protecting life. The government has all the duty to protect the right to health of its subjects. Your Lordship, in the case of Paschim Bengal case Mazdoor Samiti versus State of West Bengal, the Supreme Court held that Article 21 imposes an obligation on the state to safeguard the right to life of every person. Your Lordship, failure on part of the government hospital to provide timely medical treatment to a person in need of such treatment results in violation of right to life guaranteed under Article 21. Also in the case of Consumer Education and Research Center, Your Lordship, it was held that The right to health and medical care is a fundamental right under Article 21. In the instant case, Your Lordship, COVID-19 pandemic is exposed that the government's low priority over health sector of Indus is they have just spent 1.3% of GDP was spent on the public health care, while economically developed countries have spent as much as 17% of country's GDP towards healthcare. For a country with 135 crore population, Indus has approximately 45,000 private hospitals and 25,000 public hospitals. Statistically, there are only 5 hospital beds for every 10,000 people, which clearly shows that the government of Badlapur was negligent in building medical infrastructure and proper medical facility to the citizens of Indus. And the government has failed in performing their statutory duty to provide healthcare facility. Hence, there is clear violation of fundamental rights in the instant case, Your Lordship. Your Lordship, if there are no queries, with your kind permission, may I now call my co-counsel to proceed with issue 3 and issue 4?
Yes.
Much obliged, Your Lordship. It was indeed an honor representing the petitioners before the bench.
Good luck.
Much obliged, Your Lordship.
Yes.
Your Lordship, am I audible?
Yeah, audible.
Much obliged, Your Lordship. The council seeks permission to address the bench as Your Lordships.
Permitted.
Much obliged, Your Lordship. Your Lordship, the current council will be dealing with the issue 3 and 4, Your Lordship. Under issue 3, the council will be dealing whether there is a violation of fundamental rights of Mr. Chatri and others, Your Lordship. And the current council will be dealing this issue under 4 heads. That is, there is a negligence of state, and I will be proving the negligence under 3 subheads, Your Lordship. Duty to care, breach of such duty, and the consequential damage. That there is a clear nexus between the violation of their duty to care and the consequential damage, Your Lordship. And unpreparedness of the state to the second wave of the COVID, and act of medical care is not a sovereign function, and my clients are entitled to get compensation, Your Lordship. If Your Lordship permit.
1 minute. Who is the present counsel? Yourself?
Indeed, yes, Your Lordship.
You should say I am submitting. So you are the present counsel. So
Indeed,
the present counsel means then all right. Then all right. You say sovereign function. What do you mean by sovereign function?
Your Lordship, sovereign function within a state where if a government is exercising its function for a defense or to maintain a peace and tranquility within a state where it is not answerable before this honorable court, those functions will be considered as a sovereign function, Your Lordship. But in this instant case, the act of providing medical...
Can you put it in a different way, sovereign function in a nutshell? What is sovereign function?
The functions which is exercised by the government in its sovereign authority, Your Lordship.
Sovereign function is one which is inescapable and inalienable function of a state is a sovereign function.
Indeed, yes, Your Lordship.
All right. How do you say this is sovereign function?
Your Lordship,
inescapable, inalienable, which is no. Please say how you bring this one as a sovereign function.
Indeed, Your Lordship. Here
is it a sovereign function? What is
indeed
sovereign
not,
function? You know, which is inescapable, inalienable, so a function of a state. How do you say this one is a sovereign function? Please demonstrate.
Indeed, yes, Your Lordship. Yes. Your Lordship, in this instant case, Your Lordship, the government is taking a contention that while exercising a sovereign function, we did
what
this.
What is sovereign here now? What is sovereign function here?
Your Lordship, according to the respondents, here the sovereign function is the function which is exercised by the government where they are not answerable to the
government function also can be one. See, one thing which cannot be now judicial function is the sovereign function, which cannot be given to a private. Now, this is a sovereign function, treatment and all medical hospital can be given to some other person, private person. How do you say it is a sovereign function? You are now admitting the contention of the defendant or you are denying it?
Your Lordship, the sovereign function in this instant case has been...
Thing, you are appearing for petitioner. Now, what is the defense of the state?
Your Lordship, Your Lordship, the definition, the Lordships are stating...
Defense, contention. The contention of
Your
the
Lordship,
state is what?
Defense contention.
They say sovereign function.
Your Lordship,
you approve it or not?
No, Your Lordship, it's not a sovereign function.
Which please argue on that, yes.
Indeed, as Your Lordship, the defendant is claiming that while exercising the sovereign function, they are stating that we are not answerable before this honorable court. And the petitioner for the counsel for the petition is submitting that in this instant case, it is not a sovereign function. Yes, defendant is answerable before this honorable court, Your Lordship. And stating the case of Nagendra Rao versus state of Andhra Pradesh, the apex court held that due to negligent act of the state, a citizen suffers any damage, the state will be liable to pay compensation and the principle of sovereign immunity will not apply. and continued. The same has been reiterated in Registration Society versus Union of India. The Honorable Apex Court held that the liability of the state must be made coexistence with the modern concept of welfare state. The state must be liable for all the tortious act of its employees, whether done in excess of sovereign or non-sovereign function, Your Lordship. There is no clear distinction between sovereign and non-sovereign function under the Constitution of India, Your Lordship. It's all the interpretation of the Honorable Court. And even there is no strict rule to consider which is a sovereign function or non-sovereign function. It's up to the decision of this Honorable Court to consider which is sovereign and non-sovereign function, Your Lordship. In this instant case, the act of providing medical care is not a sovereign function, Your Lordship. The government owes a duty to care towards the citizen to provide right to health, Your Lordship. But in the instant case, just to come out of their duty and just to come out of the responsibility, the government is merely stating that as a sovereign function, Your Lordship. And when it comes to negligence of the state, Your Lordship, the council will be establishing under three main issues, Your Lordship. As Your Lordships already pointed out, the council for the petitioner has to establish the negligence of the state, Your Lordship. The council would like to seek Your Lordship attention to para 4 of the Moot problem, Your Lordship, which reads as: even the top researcher and virologist has advised that patients recovering from COVID-19 would need oxygen support, Your Lordship. And at the same time, owing to the alarms given by those virologists, several private hospitals increased their order for supply of oxygen immediately as a contingency. The Health One approached the government seeking approval for placing additional order for the oxygen cylinder, Your Lordship. The government was well known and the private hospitals has taken an initiative to increase the supply of oxygen, Your Lordship, but there was any initiative taken by the government to increase the capacity, Your Lordship. It has been clearly stated under para 14 of the Moot proposition, where private hospital has increased the capacity of oxygen. But even after the Health One approached the government has not taken any initiative to increase the oxygen, Your Lordship, where the negligence of the state has been clearly established, Your Lordship. And when it comes to administration of
Mr. Counsel, is it your case that the oxygen was available in the private hospitals?
Your Lordship, indeed not, Your Lordship. Just to establish before this.
They have that is made a demand.
Indeed, Your
So
Lordship.
whether they got it and it was available.
Your Lordship, there was no case of negligence from any private hospital, and there was no cases of stating the patients have been died due to shortage of oxygen in private hospitals, Your Lordship, unlike government hospitals.
Nobody has made that case. Nobody has died in the private hospital. It is not nobody's case.
Your Lordship, but in this instant case, due to negligent act of this government only, as Your Lordship rightly pointed out, the government was also unforeseeable to see the situation. But in this instant case, the government was foreseeable and the government was well known and well aware of the need of the oxygen. In spite of that, they are failed to supply the oxygen and to give it to the patient.
The issue is like this. So availability of the oxygen was there, or manufacturing was there. And in spite of that, the government has not secured it. Then you can attribute that there was a negligence.
Indeed, Your Lordship, in this instant,
you have not made out a case that there was availability of oxygen, and the government, in spite of that, it has not secured. It has not increased this demand.
Your Lordship, the council will be establishing even that also in detail, Your Lordship.
It is your own case that you have moved heaven and earth to secure the oxygen from private also, that you could not get.
Your Lordship, the government.
It is unforeseeable.
Indeed not, Your Lordship. In this instant case, it was foreseeable, Your Lordship. To draw your Lordship attention to para 11 of the Moot problem, para 17 of the Moot problem, Your Lordship. The said act has been happened on 7th July 2021, Your Lordship. The government has already faced the COVID first wave in 2019 itself, Your Lordship. And the government has got us 18 months of time to prepare for second wave, Your Lordship. And even the top virologist within the state with the committee.
Do you mean to say that you are anticipating that there was a second wave?
Your Lordship, the second wave, the anticipation of second wave.
Who has
Your Lordship, all the
in the Moot problem itself, it has been stated. So the government has declared that the first have been closed. So there is no problem. All the conditions have been relaxed.
Your Lordship, while relaxation, while during the relaxation,
what it indicates whether the government was anticipating that there was a second wave and we have to prepare for that.
Your Lordship, anticipation of the second wave has been said by all the international medical institution, even the Medical Council of India has been said, Your Lordship, the second wave will gonna come. Your Lordship, they have given a time relaxation to open up the economic activities, but it has been predicted by the international medical institution as well as Medical Council of India that second wave will come and it will be more grievous than the first, Your Lordship.
Yes, that is the right answer that you have given, I think, for the query. See, now you want to proceed against the government. There is a constitutional obligation to protect the life. Now, to protect the life, in that situation, what was required was to establish the facility. It has established the facilities.
Indeed, not, Your Lordship.
It has established the facility. Facility is there, COVID facility. So that is to protect the life. Now, in that process, if something goes out of the control, how can you impute negligence to the government? See, there is a constitution. Do you follow the under Article 21, to protect the life only, they have established it. It is just like to give an analogy. For the public good, trees are planted by the roadside. Now, by some reason, the tree falls on your building or on the person. How can you impute negligence to the government? This is the, I think, identical situation here.
Your Lordship, to answer Your Lordship's question, Your Lordship, in this instant case, to draw Your Lordship attention to para 11 of the Moot problem, Your Lordship, the government unpreparedness will be shown, Your Lordship, for 25,000 in 25,000 public hospital, there were only 5 beds was present for 10,000 people, Your Lordship. To kindly differ from Your Lordship's opinion, Your Lordship, there were only 5 beds available for 10,000 people, Your Lordship. This is how the government was prepared for the second wave, which has already been stated, Your Lordship. To differ from Your Lordship's opinion, Your Lordship, the government was completely negligent even to prepare for the second wave, Your Lordship. If they would have been...
You should be very clear. He died due to lack of oxygen, not for want of bed. So you should not confuse. You should be very clear. It is not for want of bed. It is for want of oxygen. So their facility is there. All arrangement is made in good faith to protect the life. Something goes amiss. Does it fall within the ambit of negligence or lack of due care and diligence? That is the only issue.
Indeed, yes, Your Lordship. Even in the instant case, Your Lordship, the COVID-19, which in spite of all other medicines or the vaccination, Your Lordship, even the WHO has been said, Your Lordship, no medicine may cure the COVID-19 pandemic, but the oxygen and other basic medicine are required to treat the patient, Your Lordship. And in this instant case, considering all other medical facilities, oxygen should be given as a paramount consideration by the government to treat the patients of the COVID-19, Your Lordship. And in spite, the government may be prepared for other medicines, which is not deemed fit to be treat the COVID-19. The oxygen was the sole lifesaver in this instant case, Your Lordship. And government has neglected on that sole lifesaver itself, Your Lordship.
Good, that's right.
Mr. Counsel.
Much of that.
So in order to, that is, sue for tortuous act.
Indeed, Your Lordship.
The basic rule under the torts is, you be just, you be remedium. That where there is a right, there is a remedy.
Indeed,
so I know that you will bring under Article 21. That is right to life.
Indeed,
so whether a right to life, that whether we can analyze like this, saying that right to life, it includes livelihood. So whether the government is likely to provide oxygen also.
Indeed, yes, Your Lordship.
So how that? Nobody can anticipate.
Your Lordship, it should be anticipated.
That is, you take that is the case of India itself. That is 1 crore 30, that is million, that is people are there. So is it possible for the government to provide oxygen to all these people by anticipating that the COVID will come?
Indeed, Your Lordship, but in this instant case, Your Lordship, not all the 135 crore population has been infected with the COVID, Your Lordship. Several percentage of people was infected with the COVID, and government should be competent.
How that is divided percentage-wise? How that you are divided?
Your Lordship, as per the statistics, Your Lordship,
for the COVID care, supply of continuous supply of oxygen was the essential thing that should have been taken care of. That is what we have already made a point.
Yes. Your Lordship, as per owing to the statistics of the government itself, Your Lordship, out of 135 crore population, 5,35,435 people was infected with the COVID, Your Lordship. Not, it is very less than 5% of the total population which was infected by the COVID, Your Lordship. And out of that, only 5 lakh people was dead. Your Lordship, not even a 3% of the overall population was infected with the COVID, and government has failed to provide medical service for even the 3% of COVID patients, Your Lordship. And Your Lordship, when it comes to, as Your Lordship rightly pointed out, even the torture liability and the compensation provided, as it has been established under D.K. Basu's state of West Bengal, the Apex Court has evolved that right to compensation in cases of establishing unconstitutional deprivation of personal liberty, Constitution will grant a compensation for violation of fundamental right to life, Your Lordship. And it was held that the defense of sovereign immunity is not available in such cases. And Your Lordship, it has been further restated in Patel Roadways versus Manish Chotulal case. It has been held that, Your Lordship, vicarious liability is in case of joint torts. This obiter dictum that the judges hold proves that opinion that since there was two parties who are of a principal agent relationship, where the negligence has occurred, both Health One and state of interest need to be held liable to pay compensation in this instant case, Your Lordship. It's a negligence of both Health One and the government in this instant case. Even after Health One approached the government to grant an excess supply of the oxygen, the government took no initiative to get more oxygen in this instant case, Your Lordship. And when it comes to the medical infrastructure, what this government has owned, as already stated by my other council, Your Lordship, for an 135 crore of population, only 1.3% of GDP has been spent for health sector, Your Lordship. It is highly unreasonable, Your Lordship. And even the bills which the hospital authority is claiming, as Your Lordship rightly pointed out, it's an COVID recovery facility set up by the government. And under Article 21, the government is completely obliged to provide free medical care service to its citizen, Your Lordship. In spite of that, they have given a 20 lakh bill to the patient, Your Lordship, which out of which they have completely lost the whole family, the auto rickshaw, and the overall life savings has been taken away by the government, Your Lordship. Which is nothing but
we can direct the government not to claim that medical bills because
Your
it is for COVID. So that, but compensation, how we are entitled? How do you say Article that 21 is infringed by the state? The state has not done anything. It's a virus act, and virus suffered because of the virus, and also added to that you had suffering from asthma and all. And the only thing is oxygen was not made available because the paucity of things and all. That's all. So under such circumstances, saying that there is a total negligence or deliberate negligence on the part of the government cannot be accepted, and that's not possible. So government giving 22 lakhs, what is it they spend? Is it a high-tech hospital or what? You are simply for the sake of case you are making it. For the sake of case you are making 22 lakhs. What is this? Is it high-tech hospital? Government high-tech hospital. The government has brought the regulation that this much only charge, private hospitals should charge so much money only for COVID. For bed, everything is controlled, and taken a lot of care and caution for everything. Government has taken. There cannot be said anything negligence on the part of the government.
Your Lordship, in this instant case, the council to the petitioner would like to grab your Lordship attention to para 16, Your Lordship, where it states, owing to the acute shortage of hospital beds, Tupden was shifted to COVID recovery facility, Your Lordship, which implies that it is not a well-equipped hospital, Your Lordship. There was already a shortage of hospital bed, which the fact sheet, para 16, which states.
Now you are probably, the facts are not because all hospitals, schools, colleges, and so many chowdhuries were converted into hospitals like. So you are only for the say, you have not brought all those facts on record. You have conveniently omitted those points. So many beds were because what is that indoor sports audit indoor thing and all converted into hospitals. Beds were, but you have conveniently omitted those things.
Indeed, not, Your Lordship. Your Lordship, as Your Lordship rightly pointed out, the bill of 20 lakh, if it is not a multinational hospital
it is
to
not
claim
a high-tech hospital, all right. If any money, have you paid the bill?
Indeed, Your Lordship, after selling auto rickshaw and all the
will ask the government refund that amount if you have paid it. But by selling auto rickshaw, will you get 22 lakhs?
Indeed, not, your lordship. It's all the life saving which has been said. Not only Mr. Chatri and all the remaining who died, they have even equally paid the bills of the hospital, your lordship. And this honorable court should not consider this loss of life as a very vague thing, as the respondents has been claiming that no lives were lost due to oxygen, and it's a life which has been lost. The Article 21 clearly says right to life is
right to. Article 21 is a very we can interpret, but here non-supply of oxygen cylinder, you cannot infringement of state has infringed your fundamental right to life. You cannot take it like that.
Your lordship,
Yes.
in this instant case, there is a loss of life, your lordship. There is nothing more than losing a life to violate Article 21, your lordship. Even the apex court has been held right to livelihood is a fundamental right while living, and providing essential medical care during living is a fundamental right. And in this instant case, the death has been happened, your lordship. Not only one, there are Chatri and Miss 7 others, and including other family members in this instant case, your lordship. And this honorable court should consider the death of all those is in violation of strict violation of fundamental right under Article 21, your lordship. And my clients are clearly entitled to get the compensation even under the tortious liability of government and health one, and even under the constitutional laws provided by the constitution, your lordship. And it has been further reiterated in Haribabu Kauda versus State of Maharashtra, your lordship. The court held that the state cannot claim sovereign function as a defense for vicarious liability that was imposed on them for the fact that hospital negligence led to the petitioner patient to their death, your lordship. Your lordship, even though if any death has been happened due to the hospital negligence, even in this case, the government was held liable, your lordship, for the loss of life, your lordship. And owing to all the precedents set by the apex court, your lordship, in this instant case, there is a clear violation of Article 21 by the respondent, your lordship, and they cannot claim a contention of a sovereign function. Even the apex court held in various cases, the sovereign immunity will not be available under Article 21, and right to livelihood and right to life has been promised by the Constitution of Indus under Article 21, your lordship.
A week ago, Supreme Court has rendered a judgment saying that medical negligence is no ground. There should be deliberate. Little medical negligence cannot be a ground under Consumer Protection Act. A week back it came. Now here there is no deliberate attempt or action on the part of the government in not providing oxygen, because requirement demand was more and the supply was less.
As your lordship rightly pointed out.
Conclude your argument.
Indeed, as your lordship. Your lordship, in this instant case, owing to the apex court recent judgment, your lordship, in this case, the loss of life is more grievous than what it has been medical negligence held in that case, your lordship. So the council submits before this honorable court that in this instant case, there is a clear violation of fundamental right, and my petitioners are clearly entitled to get compensation, and this honorable court should consider that right to livelihood has been considered as a fundamental right, and here in this instant case, there is a loss of life. Considering that, if your lordships permit me, I will go with my prayer, your lordship.
Yes. Now, conclude your.
Much obliged, your lordship.
Conclude, yes.
In the light of issues raised, argument advanced, and authority cited, the petitioner pray before this honorable court that it may please to hold this petition is maintainable before this honorable court. There is a violation of fundamental right, and direct the government to pay compensation of ₹10 crore to the deceased and their families, and pass any order, direction, or relief that it may deem fit in the interest of justice, equity, and good conscience. And for such act of kindness, the petitioner as in duty upon shall ever pray. And it's a great pleasure arguing before this honorable court, your lordship.
Good. Goodbye. Yes, next.
Honorable greeting to the bench. Am I audible and visible?
Yeah, audible.
Permission to refer to the bench collectively as your lordship.
Yes.
Your lordship, the council is deeply honored to present the defendant's case before this honorable court in the matter of Chetri and others versus the Union of Indus and another. If your lordship is privy to the factual matrix, the council has although one clarification to make to the factual matrix before it proceeds to address the jurisdiction and the issues of the present petition. The contention that we have with the factual matrix, your lordship, is that Health One is in the defendant's case, in the petitioner's case, your lordship, they have said that they are suing the hospital. However, in the present case, your lordship, they are suing Health One, which was an independent contractor of the government and was just supplying oxygen to the COVID recovery facility. They were not running the COVID recovery facility, and they were just an independent contractor to the government. That is the clarification that I would like to make as to the statement of facts, Your Lordship. If I would move further forward, Your Lordship, I would like to challenge the jurisdiction with which the petitioners have filed the current writ petition, Your Lordship. As to the jurisdiction, Your Lordship, under Article 226, Your Lordship, the petitioners have put the petition both against the government and Health One, Your Lordship, and the petitioners are contending that Health One fundamental rights can be claimed against Health One, which is a private body, Your Lordship. It is an independent contractor of the government, Your Lordship, and the petitioners have not made out in the argument that Article 12 applies to Health One, and that Health One is an instrumentality of the state. Such an argument has not been maintained by the petitioners, Your Lordship. Therefore, the council submits that the suit against Health One the writ petition against Health One specifically should be dismissed, Your Lordship.
1 minute, is it a suit or PIL?
It is a PIL, Your Lordship, and we contend that filing it as a PIL too is incorrect, Your Lordship, because the petitioners do have locus standi in the present case. To say that it is a PIL
but you are saying it is a suit. You are saying as a suit, but is it a PIL? Because their contention it is a PIL. The argument is also whether PIL is maintainable or not. What is your argument on the PIL? And if it is on the alternative, it is treated as a suit. What is the argument?
Your Lordship, we argue that the present case should be treated as a writ petition.
It
is a writ petition.
Article 226, the question of filing suit as well. So it is in Article 226, a PIL has been filed. Is it not? It is a PIL or a simple writ petition or a private litigation.
So, Your Lordship, we submit that it should be a writ petition and not a PIL because the present petitioners have locus standi to the case. There's no question of a public interest in the present case, Your Lordship, because they are suing for their own interest, their own private interest, Your Lordship. Furthermore, we submit that under the writ petition, Your Lordship, they cannot make Health One a party to the case. They could separately perhaps sue Health One under the CPC, Your Lordship.
No, when it is maintainable, writ petition maintainable against the state, now it is a contract given or whomsoever, it makes no difference because state is there. So it is maintainable. In Article 226 against the state is maintainable. The seeking compensation or any relief against the state as well as vicarious liability. They are putting vicarious liability. For the negligence on the part of the respondent number 1, that is Health One. Now for negligence on that part, they are asking it is a vicarious liability on the part of the government. How do you say that? Why should they bring it under Article 212 and all? There is no such need for your argument cannot be accepted.
Your Lordship, we are submitting that if they ask
the state, it is filed against the state, and now the contractor whomsoever appointed by the state government. So under such circumstances, they need not establish that Health One is coming in Article 12 of the Constitution. It's not correct. What is that? The vicarious liability. Even if you say the Health One is given a contract, for their negligence, the state is liable. That is called vicarious liability.
Yes, Your Lordship. We are submitting that if the petitioners are claiming compensation against Health One, that cannot be maintained from the present suit.
You are not holding the brief for D1, D2.
You are holding brief for D1, I mean state or Health One?
We are the defendants for both, Your Lordship.
You are appearing for both. So your argument is on behalf of Health One. Respondent.
Yes, Your Lordship.
Yes, proceed.
So, Your Lordship, that concludes my contention as to the jurisdiction of the case. We reserve our right to also argue on the merits of the case. Therefore, Your Lordship, may I proceed to the arguments that we will proceed on this case, that the council will proceed?
Yeah, proceed.
Yes, Your Lordship. We have 3 submissions, Your Lordship, as to the present case, that the improper supply of oxygen by Health One does not constitute negligence, and that the government is not vicariously liable if in arguendo it is accepted that there was negligence on part of Health One. There can be no vicarious liability even then established on the government. And the third issue is that there is no statutory or constitutional liability on the government. The last two issues will be dealt with by my co-counsel. If I have your lordship's permission, I will proceed with the first issue.
Yeah.
Thank you, your lordship. Our submission, your lordship, is that Health One did not owe any duty of care to the petitioners, your lordship. In the famous case of Caparo Industries versus Dickman, the House of Lords in the United Kingdom established that proximity between the claimant and the defendant is an important element of proving negligence, your lordship. To deduce any duty of care, all the elements have to be fulfilled. It has to be firmly established that the independent existence of proximity is there. We submit, and that the defendant cannot be liable to an indeterminate class of people, to which we submit that the present petitioner belongs to. Health One was to supply medical infrastructure to the CRF, and by this doctrine of closeness, it does not interact with the petitioner in any way whatsoever. Its dealings are with the CRF and the government only. There is no prior relationship between the parties. We cannot consider an omission to act as actionable negligence on part of Health One, since they have no duty of care whatsoever towards the petitioners.
Yes, we'll exonerate D2. We'll impose the liability only on you only, on defendant number 1, on the state.
Thank you, your lordship.
Did not take a strain. Yes. Yes.
Proceed. Yes, your lordship. If that argument, if your lordship proceeds that way,
that's why you want that no liability should be this one fastened on D2.
Yes, yes, your lordship.
Yes,
and we submit, your lordship.
Yes.
Yes, your lordship. If we submit, if that contention is accepted, your lordship, the consequence would be that there would be no vicarious liability on the government to your lordship. If the petition against D2 is dismissed, your lordship, then there would be no vicarious liability against the government to your lordship. That is our contention, your lordship. Therefore, we also would like to contend, your lordship, that under the tort of negligence, it is not maintainable because the plaintiffs also knew about the shortage of oxygen, your lordship. They cannot contend that it was that the government took no steps to maintain the oxygen facilities in the CRF. Your lordship, the pandemic was unforeseeable to the extent of the specific scale and the specific degree to which the oxygen would be required, your lordship. It cannot be said that the government took no actions as to arranging oxygen, your lordship. However, the specific amount of oxygen that was required was certainly unforeseeable, your lordship. It is submitted that there was a huge demand for oxygen supply in the country due to the rapid and unprecedented spread of the second wave of the pandemic. There was a concurrent increase in demand for oxygen by several private hospitals too, your lordship. In this regard, it is inevitable that there will be a crunch in supply of oxygen, especially due to the fact that no country, and specifically a developing country like the Republic of Indus, has unlimited resources, your lordship. We would like to rely on the case of Jacob Matthews versus State of Punjab, your lordship, in which the Supreme Court stated that when the charge of negligence arises out of failure to use some particular equipment, the charge would fail if the equipment was not generally available at that point of time on which it is suggested as should have been used. In these circumstances, it is impractical to believe that the plaintiffs were not aware of a general shortage of oxygen in the country and nothing was latent. Your lordship, is there any questions on the issue of negligence, your lordship?
Why did you set up this facility?
Yes, your lordship.
Why did the state?
So there was a sudden increase of cases, your lordship, and the government was acknowledged that sudden increase, and therefore they established new facilities in which people could take healthcare facilities.
You established that facility to protect life, to give the health care.
Yes, your lordship.
Now, what is the use when you set up a facility and you do not provide the necessary facilities therein? You set up a Indira canteen, you do not give gas at all for cooking. What happens? Can you say that still I'm very diligent in seeing that the purpose of setting up the establishment or the Indira canteen is served? You have performed your legal duty under the Constitution?
Yes, Your Lordship. Our legal duty was to establish the facility, and we also provided oxygen. We are not contending. Our submission is, Lordship, that we provided and ensured that there was a certain supply of oxygen, Your Lordship. But in the present circumstances, due to the unforeseen nature of the COVID pandemic, Your Lordship, the amount of oxygen did not match the amount of oxygen required. Therefore, this mismatch in the specific amount of oxygen cannot constitute negligence on part of the government, Your Lordship, and cannot constitute a disregard for the duty placed on the government, Your Lordship. If I were to refer to the facts of the case, Your Lordship, in paragraph 12, it is stated the government set up one such COVID recovery facility in the state of Badlapur. As a COVID recovery facility had several varying requirements, the government engaged a company called Health One, who had tasked with ensuring an adequate supply of required medical infrastructures and consumables. Our submission then, Your Lordship, is that the government ensured prima facie that there was an adequate supply of oxygen. The government ensured that by contracting, by putting out the tender offer through which they acquired Health One as a contractor, that there would be a supply of oxygen in the CRF in Badlapur. Furthermore, if we were to refer to paragraph 14 of the statement of facts, Your Lordship, the government also instituted various free vaccination camps for the adult citizens of the Republic of Indus. And there was also awareness camps with advertisements that were set up to make sure that information is duly passed on to the public, Your Lordship. Therefore, we submit that all the burdens that are placed on the government for the right to life under Article 21 has been fulfilled. And certainly there cannot be any argument for negligence on part of the government, Your Lordship.
What about your defense on sovereign function defense?
Yes, Your Lordship. My co-counsel will be taking up with that issue.
Okay.
Will be taking up that issue.
Time is over. Still,
no, Your Lordship.
Proceed.
Yes, Your Lordship.
Yes.
If the argument as to the jurisdiction of the present case is settled, do the Lordships proceed to dismiss the case against Health One?
You proceed to argue the case. We will decide on which count we will have to decide the case.
Yes, Your Lordship.
Why you couldn't invite an order at the preliminary stage itself? Regarding the jurisdiction, why you could not invite an order, if that is your argument?
The plaintiffs in the present case argued that Health One is a hospital only in the oral arguments, Your Lordship. Therefore, our contention arises from the oral arguments of the petitioner, Your Lordship, that a claim would also arise against Health One. If the case of the petitioner was that only the government can be made liable under the statutory or constitutional duty, then we would argue the case on the merits, Your Lordship. However, in the present case, they are also attempting to establish negligence on part of Health One and the government, due to which we want to establish that there is no jurisdiction under the writ petition to try Health One as a private body, who is breaching fundamental duty, fundamental rights, Your Lordship. That concludes my submission of arguments, Your Lordship. If it was an honor to argue before the court, now my co-counsel will take up the remaining two issues. Thank you, Your Lordship.
Okay. Thank you. Good luck. Next.
Your Lordships, am I perfectly audible and visible?
Yes, audible. Welcome.
Thank you, Your Lordship. Much obliged. I'll be making two submissions before this court. Firstly, the government cannot be made liable in case there is any deficiency in performing its sovereign function. Secondly, the government cannot be made vicariously or statutorily liable in the present case scenario. The council seeks permission to proceed with the first submission.
Yes.
Thank you, Your Lordship. It is submitted that firstly, in the very first place, there was no deficiency on the part of the state with respect to taking actions in order to deal with the pandemic situation. I would like to bring the court's attention to para 11 and 12 of the Moot proposition, wherein it is evident that the government had set up COVID recovery facilities, taking into consideration the acute shortage of medical infrastructure, and had also hired Health One to ensure an adequate supply of medical requirements like sanitizers, medicines, oxygen supply, amongst other requirements. Also, to bring to notice the efforts that have been taken by the government in such unprecedented times of COVID, it is evident from paragraph 14 of the Moot proposition that the government had even organized free vaccination camps for senior citizens, along with the awareness camps through advertisements, so that the public can take the precautions, taking into consideration the situation of COVID. Now, if there is a contention from the plaintiff's side that the government did not fulfill its duty to be acknowledged, there needs to be a consideration that the government did everything it could. It was held in the Jacob Matthew versus State of Punjab and another case, which has already been mentioned by my co-counsel, but just to emphasize on the judgment that the Supreme Court held, that when the charge of negligence arises out of failure to use some particular equipment, the charge would fail if the equipment was not generally available at that point of time on which it is suggested it should have been. So this clearly indicates that one needs to have a pragmatic and a more reasonable approach with respect to the resources that is available at the government's disposal. It is not possible for any government of the country to ensure to take care of the needs of each and every citizen, that too in a very unprecedented and unforeseen situation of COVID-19. The government does not have unlimited resources at their disposal to take care of everything and every time, and that too without any kind of mismatch that can happen. There is no denying the fact that the government owes a general duty towards its citizens, especially in such unprecedented times like COVID-19, which was so unforeseen. But with regards to the medical care in such times, there is a general duty, but it needs to be considered that the present case scenario, the government took all steps and measures that it could in order to deal with the situation. Just to bring to the court's notice, the 15th Finance Commission, under its recommendations, had clearly stated that when it is a policy decision on the part of the government, like there was a contention which was brought up by the Petitioner's Council as to the allocation of resources from its GDP, just to be clear as to the recommendations that were given by 15th Finance Commission, that it is not possible that all the resources in all terms that the government has in its disposal can be given for a particular purpose. The future contingents, and there are numerous factors that a government of a country takes into consideration while allocation of resources. So if there is a contention that there was a breach or there was a deficiency on the part of the duty that the government had towards the citizens in a general manner that has not been fulfilled, it's not evident from the facts and circumstances of the particular case. Also, if this mismatch between the demand and supply, where it was very difficult on the part of the government to procure or to get the...
It is, Mr. Counsel, it is not only a mismatch. So the simple theory of a negligence is, under the circumstances, what a prudent man could have done. If you have not done, so it is a negligence.
Indeed, Your Lordship. I would just like to clarify whether I'm audible.
Yeah.
Thank you, Your Lordship. Much obliged. Yes, Your Lordship, taking that into consideration, that had been there a case that there was a pandemic and the government had not taken any steps and measures that it could from its end In that particular case, it was a clear case where the government could have been made liable. But in the present circumstances, it is not possible. The government did whatever it could from its end. Now, also, if something like this, where the adequate supply of oxygen was to be maintained, if there has been a deficiency, if we name this as a deficiency that was not in the control of the government and it couldn't have done anything for it, if this deficiency is being contended as a breach of duty, then even then the government cannot be made liable, because firstly, I would like to draw the court's attention to the judgment that was given in Nagendra Rao and Company versus State of Andhra Pradesh. It was very clear.
You admit there is deficiency. Only thing is, you say that if there is, even if there is some deficiency, you cannot impute anything to you. But you admit that there is deficiency.
No, Your Lordship, I'd just like to make a clarification. The statement that I stated was, if there is a contention on the part of the petitioners that this mismatch of supply and if this can be named as deficiency, that was the statement I made, Your Lordship. So if this is seen as a deficiency, and
there cannot be an hypothetical argument on hypothetical situations. Yeah, the facts are in black and white. You should meet that case. They have come up with a specific case that you owed a duty. Now you yourself admit that there is a duty arises under the fundamental rights. Then what is the standard of care that was required? Was there any shortfall in that is the only issue. Now you yourself admit there is deficiency.
Indeed, Your Lordship, that is exactly what the councils of defendants has been trying to establish from its end, that the government had taken all the relevant steps and measures. And this argument, which I was just about to bring up, it is an in arguendo argument wherein the government cannot be made liable for
Mr. Counsel,
serving its
liability is another part. Further, that you admit that there was a shortage of oxygen and there was a mismatch.
Your Lordship, I'd just like to say that what proposal I have from the side of the defendants, that
I have another question. So here, if there is a shortage, and whether that is due to shortage of that is oxygen, any lives have been lost.
Your Lordship, there was shortage in the supply of the oxygen, but for that it cannot be the government or the health one cannot be made liable for it, because
if that
all
is
the
the
duty
case,
of care.
you come to paragraph number 18 of the Moot problem. So you have made a statement in the social media platform stating that no lives were lost due to shortage of oxygen. It itself shows that you are negligent.
Your Lordship, I'd just like to make a
So why that you made such a statement?
Your Lordship, I admitted to the fact that there was a shortage of oxygen, but I never said that the lives have been lost due to the shortage of
the facts itself says.
Your
on
Lordship,
social media platform that you have given a statement.
Your Lordship, I stand with what has already been released in the social media, that there has been no lives lost. I am not admitting that there has been lives lost. What I admitted was there was a shortage on the part of the oxygen supply. I never admitted that there was lives lost due to that. I completely take that stand, Your Lordship.
Okay. Now there are two issues now. Whether you admit there is negligence or no negligence. One, whether you admit there is negligence or no negligence, because your contention that it is a sovereign function so that you are not liable, you are taking that contention. Thereby it is implicit that you are admitting your negligence on your part. You are taking the contention defense of sovereign function. So that implies that you are admitting negligence on your part in not supplying a sufficient number of cylinders of gas. Is it not? So which contention you want to take it? If you admit there is negligence, it is because you are taking the contingent sovereign function. It is implicit that you are admitting negligence.
With all due respect, Your Lordship, I am not in
All
any
right,
way
you give up that
admitting
sovereign
that.
function. You give up sovereign function. You cannot take both that. So
Your
you are
Lordship,
taking negligence. First you say there is negligence or no negligence. If there is
there
negligence, then
there has been no breach of duty on the part of either of the defendants. That is the stand that
no breach, no breach.
there has been no breach. Yes,
No
Your Lordship.
negligence, no negligence on the part of the state.
No negligence. Every
So there
step
was no
and
death. The person did not die. The person, petitioner's father, did not die on account of COVID and
no,
non-support.
Your Lordship. No, Your Lordship. There were no lives lost. Rather, what
No,
that
then you are
incident.
disputing the very case of death. Then you are disputing the very case of death. When he did not die because of the non-supply of oxygen, then you are contended there is no death at all. Then see one
Your
thing,
Lordship,
your defense is negligence. Whether there is negligence or no negligence. If you are taking there is negligence, then sovereign function. You address arguments. Your argument should be on these two counts: negligence or no negligence. Because you have already taken sovereign function, the ground, so that it is implicit that you are admitting the negligence on the part of state or your instrumentality, that is your subordinate, and to the contract was entered in. Because of failure on its part, it reflects on that is vicarious liability on the part of the government. Please argue on this point. Sovereign function, you have not said anything. Are you taking that contention or not?
Your Lordship, it is an inarguendo argument that has been placed. I am not in any way admitting that there was negligence on the part of either of the defendants. I completely stand with that.
All right, there was no negligence. Even if there were to be negligence, you are taking the defense of sovereign function.
Exactly,
right,
Your
please
Lordship.
argue on the point of sovereign function and conclude it. How much? Please, how do you say that it comes within the scope of sovereign function?
Yes, indeed, Your Lordship. Firstly, to have a more better understanding of the sovereign functions, the sovereign functions are defined as the non-delegable functions that cannot be delegated to any entity by the state. Also, it was held in the Nagendra Rao and Company versus State of. Am I audible, Your Lordship?
Yeah, you are audible, but you're audible, but your image is only standstill. And now, all right, at least you are audible, but your image is standstill.
Your Lordship, I think there's a technical glitch at my
We are
end.
able to hear you, no problem. See one thing, how do you say that it is a sovereign function now? Running hospital and taking care of the patients and all is a sovereign function. How do you say it is a sovereign function? Cannot we entrust this task to some private hospital? How do you say? Where is your friend?
Your Lordship, I believe there's some internet connection. We request lots of internet connection. We request 2 minutes for him to rejoin.
So you want to pause? Okay.
Yes,
let him come.
Thank you, Your Lordship.
Let him come.
Your Lordship, can you hear me?
Yeah, please come. I'm able to hear you, but your yes, proceed.
Yes, Your Lordship. Now I'm audible and visible.
You are audible and we can see your movements. Please argue on the point of sovereign function.
Yes, Your Lordship. First,
how do you say this function becomes sovereign function?
Exactly, Your Lordship. I'm coming to that. It was clearly held in Nagendra Rao and Company versus State of Andhra Pradesh.
No, what is don't go to the citation. Please say, how do you say this is a sovereign function? What is that function? How do you bring it within the scope of sovereign function? You establish.
the very definition of sovereign, like it can be established in the way that the
All right,
very
what is this?
primary and inalienable functions of the
No,
state.
one thing. What is that health? Health. It is health. How, what is the function? Please say what is the function?
I'd just like to make a clarification.
Yes.
I could not get you. Can you please repeat your question, Your Lordship?
Well, now you say it's sovereign function. It is a sovereign function, so that you are not liable for vicarious liability. That's your contention. How do you say this one is, how this matter comes within the sovereign function? This,
Yes, Your Lordship.
yes.
Yes, Your Lordship. I am firstly, I am arguing on the, I am substantiating that establishment with the judgment that was given in Nagendra Rao and Company versus State of Andhra Pradesh. It was very clearly held that the state has sovereign protection from liability when a default has been committed to carrying out the primary and inalienable functions of a constitutional government, such as administration of justice, maintenance of law and order, and
Yes.
regulation of criminal acts, amongst other functions. Now,
Yes.
what is being taken into consideration, taking care of the present case and scenario, this amongst other functions is very clear that the court was not limiting the extent of the sovereign function.
No, it cannot be brought on within the scope of others. Others means that it only state has to do it. It cannot be entrusted to a private agency. Now, hospital, you can run it by yourself, or you can give it to a private agency, they will run it. So that will not fall within the scope of sovereign function. Sovereign function means inescapable, inalienable function of a state. Now, military, police, maintaining law and order, administration of justice, all sovereign function. But running a hotel and running a train, running a metro, running a bus, now buses are run. There is all state running, that is the state buses. Would you say that is sovereign function? In the case of accident, they are not given. It will not fall within the scope of sovereign function. Your defense on that ground, your defense on the ground of sovereign function will not sustain. It is not a sovereign function. It is your duty, state duty to your under Article 21. Article 21, you are entitled to protect because providing oxygen to the hospital and where all that. So don't bring a sovereign function. Negligence, whether there was negligence or not. That's the only defense. Sovereign function, you cannot take the defense under sovereign function. Who said for
Your
that?
Lordship.
Yes. Yep. Yes.
Your Lordship, if I may have your...
Yeah, please complete 5 more minutes.
Yes, thank you, Your Lordship.
Yes.
I may move to my next submission,
Yes.
which deals with the statutory liability on the part of the, which deals with the vicarious and statutory liability on the part of the government. Now, merely for the sake of the argument that has been put forth by the plaintiffs, that if we take into consideration that there was any negligence on the part of the health one, even then the government cannot be made vicariously liable for that negligent act.
Please, please listen. Now there is a government hospital. I was told it's a government hospital. Government hospital makes contract with supply of medicine and gas and other things. It is a contract. It is a contract between the government, that is the district hospital, DHO, and the person supplier. So now supplying medical supply appliances and all. So because there is a contract between the hospital and a person agent who was supposed to supply gas, so he has not supplied. The hospital authorities made an intent, but he did not supply because there was scarcity. So the argument would be, now you cannot say vicarious liability because he failed to do it. It's a contract between the government and the thing. There is a privity of contract. So you can initiate action against the person who has committed any breach of contract in non-supplying agency. That is between you and. So now how state can escape its liability on account of the death of the person who said to die on account of COVID.
Your Lordship, indeed, this argument in itself contains the contention that was put forth. This is in this argument basically wants to contend the relationship link that has been put forth by the petitioners, that the relationship between the health one and government is that of a principal and agent. Rather, the point that has been put forth from our end.
Mr. Arkan, your principal agent is not it is a contract. It is a subcontract between the hospital. It is not a principal agent. There is no contract of agency. It is a contract of supply.
Exactly.
It's a contract of supply. What is the, see one thing, what the agency was supposed to supply a cylinder oxygen, it did not supply. So that is a failure on the part of non-supplying. So that is as a result of it, the government is liable to pay. That's they are not saying contract of agency. Are they saying?
Yes, Your Lordship. As per the submissions that were made by the petitioners council, they have said that there has been a contract of agency between the two. Rather, what we contend is there exists a relationship of independent contractor and employer.
That's not correct. There is no contract of agency like that. It's a contract of supply of goods. Contract of supply of goods. There is no contract of agency.
Indeed, Your Lordship, I'm completely in conformity with it.
Yes.
With your permission, I may move to my last submission.
Yes. Yes.
The last submission deals with the statutory liability of the government. I would just like to present before this case, before the court, that it is submitted that under Section 73 of the Disaster Management Act, no suit shall lie against the central government in respect of any work done or purported to have been done or intended to be done in good faith. There has been no definition of this term good faith in the statute itself, but as per the General Clauses Act 1897, it clearly defines that good faith is a thing that shall be deemed to be done, shall be deemed to be done in good faith, where it is in fact done honestly, whether it is done negligently or not. So the argument basically says that good faith contemplates an honest effort to ascertain the facts upon which exercise of the power must rest. It is submitted that the good faith of the government is clear from the fact that the government acknowledged the veracity of the pandemic and engaged Health One at the right time. It did so in good faith. It has also organized the awareness camps and vaccination centers that has already been mentioned by my co-counsel and in the previous submission. Hence, it is submitted from our end that the government cannot be made statutorily liable under Disaster Management Act.
Yes.
If I may have the permission of your lordships, I may move to the prayer.
Yes.
Please much obliged, your lordship. Wherefore, in the light of the issues raised, arguments advanced, and authorities cited, it is humbly prayed that this honorable court may be pleased to declare that the dismissal of the suit as not maintainable, the improper supply of oxygen by Health One does not constitute negligence, the government cannot be made vicariously liable, the government has not failed to perform its statutory duty, and the court may pass any order, direction, or relief that this honorable court may deem fit in the interest of justice, equity, and good conscience. Thank you, your lordships. It was an honor pleading before the court.
No, your prayer to pass any such order as this court deems fit in the circumstances of the case is not correct from your side. It is applicable for the petitioner, but not for the respondent. You understand? You cannot say the pleading also differs. As you are representing that government, respondent, only ask for it. You cannot ask for pass such other order as deemed fit. It is for the petitioner to ask. Why are you asking it? You got the point?
Yes, sir.
You cannot say dismiss and pass such other order as deemed fit in circumstances means what? No. You are promoting or supporting the petitioner cause. Thank you. Good luck.
Your lordship, for the petitioner permission for rebuttals, your lordship.
Yes, please rebut.
Much obliged, your lordship. Your lordship, it's submitted before this honorable court, your lordship. What the submission made by the defendant is nothing but clear contradicting their own statement and the selective hypocrisy and they have admitted everything regarding the negligence, Your Lordship. In spite, the petitioner has proved before this honorable court, Your Lordship. When it comes to maintainability issue, Your Lordship, there was no written submission made by the respondent regarding the maintainability, Your Lordship. That is the mere arguments made before this honorable court. It's humbly submitted before this honorable court not to consider those arguments, Your Lordship. And further, Your Lordship, the respondent themselves has admitted that being a petitioner has a locus standi, and there is no rebuttals made by them regarding the locus standi, Your Lordship. Even they were clear. And Your Lordship, it has been clearly admitted before this honorable court that there was a shortage of oxygen and there was a mismatch between the supply and the need of the oxygen. It is up to the wisdom of this court to consider how negligent the government was.
But you say, is it a contract of agency between the government and the gas supplier? Is it a contract of agency?
Your Lordship, in this instant case, even the defendant misleaded this honorable.
Health one. What is the relationship between the government and the health one?
Your Lordship, it was a contractual obligation which has been between the government.
Please say you have taken the contention there is a contract of agency between the government is the principal and the agency supplier. Now, is it a contract of agency?
Your Lordship, to constitute the contract, Your Lordship, even the health one approached the government to ask for the extra oxygen. Here,
first of all, what is the dual relationship between the two? Is it a contract of agency or contract of supply of goods?
Your Lordship, it's a contract of supply of goods, Your Lordship.
But you have not taken, that's what the defense counsel said, that you have taken the contention of contract of agency. Because the failure on the part of the agent is the principal is responsible, and therefore vicarious liability is there. That's the argument of the sir. Is it a contract of agency? Is it your case is a contract of agency?
No, Your Lordship. It's a clear liability, vicarious liability, which will put Your Lordship.
How does vicarious liability come then?
Your Lordship,
what do you mean by vicarious liability?
Your Lordship, vicarious liability invokes where if there is an any wrongful act by the agent.
What do you mean by vicarious liability?
The government will be held liable for an act of
simple meaning of vicarious liability. What do you mean by vicarious liability?
An individual will be made liable for an act of other, Your Lordship.
It's not like that. The very simple meaning and definition means the negligence on the part of the workman, employer is liable to do.
Indeed, yes, Your Lordship.
Not principal, the employer is liable. So when a driver drives a vehicle, then that's a negligence. So then principal, the owner of the vehicle is responsible. It's like
Indeed,
this. Now, here you say contract of agency, but you say contract of supply of goods.
Your Lordship,
that's why vicarious liability means when there is a contract of agency or whether the supplier is a workman under the state. But you are not saying he is an employee of the thing, but you say he is an agency. You are not establishing that there was a it's not clear. There was a contract to supply. All the pleadings are not complete and.
Your Lordship, to answer Your Lordship's question, Your Lordship, owing to para 12 of the Moot proposition, Your Lordship, which read as the government engaged a company called Health One, who was tasked with ensuring an adequate supply of.
If we engage, I want to put it. Is it a contract of agency or contract of supply of goods?
Your Lordship, it's a contract of agency to supply goods, Your Lordship.
Contract to supply goods. That's correct. So there is a breach of contract between the two. It is for the state to initiate action against.
Indeed, yes, Your
So now only thing is the formal party. That is, health one is a formal respondent.
Indeed, yes, Your
Because you should implead him to establish the facts. That's all.
Indeed, yes, Your Lordship. And even
how do you say vicarious liability? How do you say vicarious liability? That's
Your Lordship, that is the misleading of the respondents, which done. Even they quoted the petitioner should have proved the health one as a state under Article 12, Your Lordship. There is no need of petitioner to prove health one as a state under Article 12, Your Lordship. The council is submitting before this honorable court how the respondents has tried to mislead this honorable court, Your Lordship. Not its petitioner contention is to clarify this honorable court how they are trying to mislead, Your Lordship.
So it is not a vicarious liability, simple liability.
Yeah, Your Lordship, the health one and the government are equally liable, Your Lordship. There where the council stated the case of state of Rajasthan versus Vidyavati, where it has been held by the apex court. Both should be held cautiously liable for the act committed in this instant case, Your Lordship. And when it comes to quoting the 15...
On what basis you have computed these damages? On what
Your Lordship,
2 crores?
22 crores.
20 crores?
Not for 20 crores, your lordship. 10 crores for Mr. Chetty and 7 others, your lordship.
Yeah, on what basis? Is there any basis to claim damages?
Indeed, your lordship, there is, as provided under the case of
Damages would be
your lordship, DK Bus was the state of West Bengal. Even the cost.
No. How many kinds of damages are there?
Your lordship, with respect to tortious act, or if any other act, if you can specify, the council will answer.
Now, what is your prayer? Please repeat your prayer. Please repeat your prayer.
Your lordship, to held that this petition is maintainable before its honorable court, and there is a violation of fundamental right, and to direct the government to grant a compensation of rupees 10 crore.
It is a compensation.
Indeed, yes, your lordship.
Compensation to what extent?
Compensation to extent of there is a loss of life, loss of livelihood of the.
So the court has to determine. Court has to determine what is the age of the deceased.
Your lordship, 50 years, your lordship.
50 years.
Indeed, yes, your lordship. There are dependents of. Your lordship, there are the whole family is dependent on the accounts of Mr.
Conclude your arguments.
Much obliged, your lordship. And even while stating para 11, 12, and 14, the respondents have clearly made a selective hypocrisy, where para 11 says that the government.
Don't use the word hypocrisy. That's not a good language. You should always polite and all. Hypocrisy and all. You are arguing case against the government. No hypocrisy.
Apologies to this bench, but it was a clear mislead by the defendants. The petitioner has to use such words because it was a clear mislead before.
Because you are repeating it, we are taking it that you are repeating it again. I noticed it. That's not the way. Language must be good, and even your opponent should be treated. The advocate has got to do 5 kinds of duties. You are an advocate, is it not?
Indeed, yes, your lordship.
You have got 5 duties.
Indeed, yes, your lordship. 5 lambs of advocacy.
Also, 1 duty to your opponent counsel. So you
with all due respect to my learned friend, with all due respect to my learned friend, it's my duty, it's my duty to protect my clients, your lordship. In spite
your client, you have got 5 duties as a lawyer. Not one duty. You have got 5 duties under the Advocates Act, ethics, professional ethics. So that you should run your language also should be very parliamentary. Unparliamentary language should not be employed.
Indeed, your lordship.
Yes.
Apologies before this honorable bench. And your lordship, the respondents has failed to establish how they have not violated fundamental rights, and they have failed to establish before this honorable court how it is a sovereign function, and they have failed to establish before this honorable court how they are not entitled to pay the compensation. With this, it's humbly submitted before this honorable court. There is a clear violation, and the respondent has clearly failed to establish all the issues which is provided under the Moot proposition. Owing to that, it's humbly submitted to this honorable court to grant a compensation and to declare this a violation of fundamental right. And it's a great honor arguing before this honorable court, your lordship.
Very good. Thank you. Good luck.
Thank you, your lordship. Much obliged.
Good luck.
Your lordship, if the counsel for the respondents might make rebuttals at this moment.
Respondent want to argue.
Rebuttal, your lordship.
Yeah, no, respondent has no right of reply. No right of reply for respondent.
Your lordship, we had reserved time at the start for rebuttal.
Okay, present. All right. That's not applicable.
Yes, your lordship.
Reply.
Thank you, your lordship. Much obliged, your lordship.
Yes.
We submit, your lordship, that the wording of this petition as a public interest petition, your lordship, makes the petition fail prima facie, your lordship, because there is no public interest in the submissions of the petitioners, your lordship. They are asking for the compensation of their compensation for the loss of their livelihoods and the compensation for the deaths of his father. But there is no public interest that they are quoting, your lordship. Therefore, the council had brought up the issue of locus standi and PIL to prove that on the face of this petition, your lordship, the arguments of the petitioners is not maintainable, your lordship.
In the rebuttal, don't repeat what is your earlier argument. That is your earlier contention.
Yes, your lordship.
It is not rebuttal. Yes.
Yes, your lordship. As to the claim of compensation, your lordship, for the deaths, the government has made an ex gratia compensation of 50,000 for every person who has died due to COVID, your lordship, under the DMA Act, Section 12 of the DMA Act, your lordship. Therefore, holding the government negligent does not follow, your lordship, and providing compensation for the negligent act does not follow, your lordship. And also, your lordship, our final submission is that the petitioners have not submitted the specific damages under which they are claiming compensation, Your Lordship, whether
You
they
are
are.
taking coup from us. You are taking coup from us.
Yes,
All
Your
your
Lordship.
argument is you are taking coup from us. They are not followed.
I do not follow, Your Lordship.
Yes, will not follow. All right, go ahead. Now your reply should be the reply to the argument made by the rebuttal argument. Now you are totally different from the thing. And what we put it to the other counsel, you are taking coup from our comments. All right, complete.
Yes, Your Lordship, my final submission is that the damages that are made out by the petitioners is not maintainable because it is not a particular way through which they have ascertained the specific amount that they are asking for, Your Lordship. With that, we submit our submissions, Your Lordship. It was an honor to argue before the court.
Good luck. Good luck. Wish you all the best.
Thank you, Your Lordship.
We thank the judges for taking the time and all the participants for being here. You're all free to leave the meeting now. Thank you.